This session is case number 24-1991, Hayes versus Christian Retirement Homes. And here on behalf of Appellant Hayes is Attorney Nicholas Shaull. Okay, and here on behalf of Appellee Christian Retirement Homes is Attorney Morgan Borron. Is that, am I pronouncing that correctly? Borron.
Yep.
All right, say again. Okay. That doesn't help me, but thank you. Mr. Shaull, whenever you are ready, you can begin your argument. Once you get settled in there, no rush.
May it please the court. Counsel. First of all, thank you for allowing me to be here to present today on behalf of my client and myself. It's an honor. It's my second time in 15 years, so I say that with caution, knowing that I might be subject to rabbit fire here in a second. But with that, a brief summary of this case, a workers' compensation case. I represent claimant Jerry Hayes, who was injured on September 12th of 2021. He was helping take some trash out on a loading dock. It was a cement floor with a extruding metal piece. He tripped on that, fell hard on the pavement, reported pain. Importantly, for the court's purposes, the defendants in this matter stipulated to the incident of injury and that it caused temporary disability. So the dispute in the case was whether or not a permanent injury was sustained. Because the defendants accepted compensability initially for the case under Iowa law 8527 subsection 4, they have the right to control care, which they did. They sent Mr. Hayes to a emergent care on September 20th of 2021, then to occupational health on September 23rd of 2021. He was subsequently sent to physical therapy. The physical therapist refused to touch the claimant because his injuries were so severe and the symptoms he was reporting were so severe. He was then referred to, and again, all directed by the defendants in this case, pursuant to 8527, he was then referred to a spinal surgeon, Dr. Michael Dolphin. Dr. Dolphin saw the claimant in November of 2021. At that time, he ordered a CT myelogram, which had not been performed yet. There were other CTs, but not a myelogram.
Is your position that once an employer sends an injured worker to a doctor of the employer's choice, that the employer's stuck with that doctor or whatever recommendation that doctor makes?
That's nuanced. That's not just my opinion. I think the case law cited in the brief makes it pretty clear that the defendants have a right to as many IMEs under 8539 as they would like, and they have every opportunity to do that, and they did do that here. However, that doesn't abdicate their duty, their affirmative duty under Iowa law, to also adjust the claim via the treating physician. To hold otherwise would allow them to doctor shop at will, which is what I would contend happened here. So to take your question a step farther, I think.
But I guess so, let's take the names out of it. Just say they go to Dr. 1, Dr. 1 recommends treatment A, right? And the employer's kind of furrowing their brow over what A is, so they're like, are you saying they can't then refer and make the claimant go to Dr. 2 to see what Dr. 2 has to say?
No, I'm not saying that, not at all. Quite the contrary. And again, that goes back to what I was saying.
Kind of what happened here?
Yes and no, and I'm going to explain what I think should have happened here under the law. What should have happened is if they want an IME, an independent medical examination, under 8539, there's no doubt they have that right. The defendants have an unlimited amount.
Is it just an IME, though, or is it a change?
Go ahead. Finish your statement if you could.
They have the right to an IME, but the law is very clear, and I cited it throughout the brief, that even if they go get an IME, they can't substitute that opinion for that of the treating physician. And what the law would mandate they do in terms of performing their affirmative obligation to adjust the claim properly is to take that IME back to the treating physician and say, hey, treating physician, what do you think about this? Express the concerns they have with lack of records, imaging. They did nothing. They They literally did nothing for about 7 months. My client was not able to treat on his own or through authorized care. Go ahead.
Well, what I'm questioning is whether the IME is the only route they can go. So let's say they send a doctor number one as a treating doc, and for whatever reason, whether they did an IME or any other reason, just decided, we don't like doctor one anymore for whatever reason. Are you saying they can't send to doctor two as a second or a different treating doc without an IME?
That's not what occurred here.
As I'm just trying to clarify, because you steered it down an IME route, and I'm not sure if it is an IME route. That's why I'm asking.
Unquestionably was an IME route. They say that throughout their emails. It's a one-time eval. The report says there's no doctor-patient relationship. This is an IME. That is an unquestioned fact in this case. What you're referring to...
My question is, can they send them to doctor two as a treating doc?
would be a different scenario. So if Dr. Dolphin makes a referral to a different treating doctor, then...
I'm saying no referral. I'm saying employer says, you know what, we've kind of lost confidence in what Dolphin's saying. We're not sure that he's doing what we want. Are you saying they can't send the employee to a second treating doctor?
That's what I'm saying. The law is very clear, cited in the brief. They get to select the doctor. They do not get to substitute their judgment for that of the treating doctor. They do not get to play doctor. They do not get to control the modalities of treatment that doctors provide. That is clear in the law, correct?
Well, they can't say, Doctor one, you can only do treatments A, B, and C, even though you wanted to do D as well. I would agree with that, but are you saying they can't send him to Doctor two to see what Doctor two has to say as a treating doc?
No, not without a referral from their authorized treating doctor, because that would be substituting their judgment for that of a medical professional. The law is clear. Insurance carriers typically are not medical professionals. What would happen there is anytime a doctor is favorable to the claimant, potentially, they don't like what the doctor has to say, well, we'll just send them to Dr. B. If Dr. A says, yes, I think, I've done all I can't help them anymore, or, you know what, I think they would actually benefit from this more substantial treatment, more aggressive, and there's a referral, then yes, they would have to authorize this. But no, they don't get to step in and substitute their judgment for that of the treating doctor. Keep in mind, they selected the doctor. This is their doctor. But it's all founded in 85-27-4 in the balance that the Supreme Court has recognized that on one hand, you have an employer who has all the control of the care and the direction of the care, and the claimant whose benefit, any doubt, is supposed to be resolved in their favor. And that's why there's a counterbalance. If the carriers are worried about that, they should do a better job of selecting their own doctors as opposed to doctor shopping when they don't like what their doctor has to say, which I would contend happened here.
On the IME route, I want to fast forward or skip to the last issue you raised in your brief, and I'm asking for your help in helping me understand that. Is your claim that your client's entitled to reimbursement for the IME that your client sought conditioned on being successful on your claim of compensability, or are you claiming he's entitled to reimbursement regardless?
I think I understood that. Regardless, in this case, because he met the prescriptions of the statute, that Dodd case holds that, and that happens all the time. Unfortunately, it just happened to me 2 weeks ago in a different work comp case where...
That Dodd case is a 2008 case, right? It is. But and in 2017, which would apply here, right, because it's post-2017, they amended Section 85.39 to add language that says an employer is only liable to reimburse an employee for the cost of an examination conducted pursuant to this subsection if the injury for which the employee is being examined is determined to be compensable under this chapter or Chapter 85A or B. An employer is not liable for the cost of such an examination if the injury for which the employee is being examined is determined not to be a compensable injury.
It was compensable. He received healing period benefits. It was accepted. It wasn't found to be a permanent injury. They stipulated to a temporary compensable injury paid benefits. So it's different code sections. You've got 8534 subsection 1, which deals with healing period benefits, compensable. Subsection 2 deals with PPD. I think as a matter of law, he's entitled to that. When the defendants arranged their IME, they selected Dr. Igram. It was being treated as a compensable case. He rendered an impairment rating that was considered too low, 0. As a matter of law at that point, that triggers the claimant's IME rights. I don't think that code section abrogates what was in Dodd, which is it only makes it clear if it's a compensable injury. This was a compensable injury for 8534 subsection 1. The judge simply determined wrongfully, in my opinion, that there was no permanent injury, subsection 2. But it was a compensable injury. They stipulated to that on the healing report, they being the defendants.
Thank you.
Thank you.
Whenever you're ready, you can begin your argument. And of course, Mr. Shaull, you'll have your 5 minutes on rebuttal if you'd like.
May it please the court, counsel. My name's Morgan Todd Borron. I represent the Appellees in this matter.
Where we ended, not to get you off book right off the hop here, but with this compensability of the IME, do you think it hinges on the success of Mr. Hayes on appeal here?
With regard to the IME, I do believe that since he was unable to prove causation and compensability of the claim, that we would not be required, defendants are not required to pay for the IME cost.
What about the argument that was pitched here that it's like, oh, it is compensable because he got like temporary TTD benefits or healing period benefits?
Receive temporary healing period benefits up until the point that defendants officially denied any further ongoing care being related to the initial incident. There was a temporary aggravation in this matter, not a permanent disability. That was the result of this.
You think that is, so your take on it is the reference to compensable in 85.39 is referring to the final compensability determination, not a temporary situation?
Is our position, yes.
Case law on that you can point to since the 2017 amendments?
Not off the top of my head, Your Honor, but I would be happy to brief the court afterwards. Okay. I just wanted to point on a few things that were discussed previously. When counsel was just speaking, he was talking about 85.27.4. That is the alternate care section when it comes to medical care in workers' compensation. If there is a compensable claim and there is no dispute about the compensability of that claim and the nature of that claim, medical care is authorized by the defendants under 85.27.1. 85.27.4 relates to alternate care, again, where there is a compensable injury. There's no dispute about that injury, but
Compensable, you're talking about permanent compensability, not the healing period benefits compensability?
we might agree that it's compensable and it's temporary and disagree later about the nature and extent.
During the temporary time, right? So you could still have a dispute about that where the alternate medical care decision needs to get triggered, right? Okay.
With alternate medical care, that's an entirely different proceeding than what we're here today for. In alternate medical care, an employee is dissatisfied with the care that's being provided by the employer, and so they're able to go to the agency and say, I'm dissatisfied with the care that defendants are giving me, and here's XYZ why, and then the agency is able to enter an order telling defendants to go one way or dismiss it and say that defendants' care that they're authorizing is fine. So what happened in this case was we were authorizing initial care after the injury occurred, and claimant had a recorded statement. He had only disclosed to the defendants in this matter that he was in a motor vehicle accident in 2018. He did not disclose any other pre-existing injuries, and there are numerous pre-existing injuries going back to like 1999. And so when that information was starting to come to light as we're collecting medical records, which is a very timely process, you send out a request, sometimes you wait a month or two to even get the records back, then you have to review them. All of this is happening during the course of our investigation. And then as Dr. Dolphin makes his surgery recommendation in December, we're just now starting to learn at that time about the extent of claimant's pre-existing condition in the same body part area. That is what's prompted the desire for the IME with Dr. Igram.
Acknowledge that it was an IME when you went to Igren?
Yeah, that's correct.
Do you agree with opposing counsel's take on things that you can't shift from Dr. 1 to Dr. 2 except via an IME. You can't just say, well, we don't necessarily agree with what Dr. 1 recommended for treatment, so we're going to send you to treating doctor number 2.
I would agree with that to a certain extent, and that's not what happened here. What happened here was Dr. Dolphin had not reviewed any of these prior medical records. We were just conducting our investigation as it's going along. We decided at that point, when Dr. Dolphin recommends surgery, we need to get another opinion from a doctor who's going to review the entirety of all of these medical records and render an opinion.
Not just going to a different treating doc.
That's correct.
Okay.
Dr. Igram to treat Mr. Hayes. We asked him to evaluate Mr. Hayes, review all of the medical records and the imaging, and compare pre-existing CTs versus post-injury CTs, things of that nature, and render an opinion whether the need for the surgery that Dr. Dolphin had recommended was related to our injury or was the result of his pre-existing disability. Dr. Igram was of the opinion that it was entirely of claimant's pre-existing disability, that the injury had temporarily aggravated claimant's underlying condition, but that the need for surgery was in fact that it was personal in nature. And so at that point, after receiving Dr. Igram's opinions, there was another little bit of a delay. There was a report that was obtained from Dr. Dolphin by claimant's counsel, and it essentially just said Dr. Dolphin believes that the surgery that he wants to perform is related to this work injury. So what we did then was take Dr. Dolphin's report and sent it to Dr. Igram to get a supplemental report from Dr. Igram to see if Dr. Dolphin's report changed his mind at all. And Dr. Igram came back and said, no, this doesn't change my mind. At that point, we issued a formal denial and say, this is no longer related to our work injury. The need for surgery, based on the opinion of Dr. Igram, is entirely of claimant's pre-existing condition, not related to our injury, and that's how that all went down.
Address the error preservation argument that you make in your brief.
I would like to point the court to, I believe it is a decision that came out of the Court of Appeals. I believe it was Judge Ahler's decision. It's Archer, Daniels, Midland versus Williams. It came out December 20th, 2023. 3 Northwest 3rd, 231. Sorry, that was kind of out of order. In that case,
But I don't know the site. 3 Northwest 3rd.
231. In that case, Judge Ahlers goes through a very similar discussion as far as error preservation. He discusses that in order for the issue to be preserved, I agree with counsel that he did raise the issues in his briefings below. He did. However, the agency in the arbitration decision and in the appeal decision never addressed the issue. And the remedy for that would be to do an application for rehearing and point to the court and say, this issue wasn't addressed, I want a ruling on it. That didn't happen. So there is no pointed issue that's still left on appeal. Error is not preserved because the administrative remedy of going through the application for rehearing was never done. And so that issue regarding defendant's investigation is frankly, in our opinion, not preserved for review. Does that answer?
Yeah.
Let's see. We do believe that this is essentially a substantial evidence case when it all comes down to it. The agency provided plenty of supplement of evidence pointing to why it came to the conclusions that it came to. It ultimately adopted the opinions of Dr. Igram over that of Dr. Dolphin and Dr. Wolf. The agency said in their decision that it was Dr. Igram and Dr. Wolf.
Was Wolf the IME chosen by claimant or IME, a second IME that you chose?
IME chosen by claimant. And so Dr. Wolf was aware of all of the pre-existing records and things of that nature as well. However, the agency determined that Dr. Igram was more persuasive because Dr. Igram actually compared a 2019 CT scan, which was before the injury occurred, and a CT scan that occurred just post-injury. And this bulging disc at L4-5, which is the disc that needed surgery, was evident on both of those CT scans. And so the agency determined that it was Dr. Igram's opinion was superior in that regard. And So claimant is asking here that you adopt the opinion of Dr. Dolphin, but Dr. Dolphin was undermined multiple times by the agency, and all of their opinions in that regard to not adopt Dr. Dolphin are supported by substantial evidence. I think that there's like a pretty long few paragraphs in the arbitration decision discussing why Dr. Dolphin was not adopted.
Down to its essence is this is a battle of the experts. The fact finder found that Dr. Igren was more persuasive, even though there can be arguments about why Dr. Dolphin or Dr. Wolf were more persuasive. Fact finder found against those, and that's the battle, right?
That is correct.
Okay.
Yes, you're on point. So I see I just have 12 seconds left, so thank you for your time. I appreciate it very much.
Mr. Shaull, you'll have up to 5 minutes in rebuttal if you'd like.
Thank you, Your Honors. Thank you. Thank you, Your Honors. A couple things. To the extent defense counsel mentioned alt med, that's a different situation, nothing to do with the case here. That's not accurate. So there are separate expedited alt med proceedings under Iowa Code, Administrative Code 4.46, 4.48 sub 6. But those are summary proceedings. They happen in 10 to 14 days. In order for the parties to participate, there has to be an admission of liability. If you read the briefing, you see the judge's May 11, 2022 order.
That admission of liability through the permanent disability, or can it be enough that it's just a temporary?
Treatment sought to be rendered. So at that time, it was for the surgery. They would neither admit or deny. So the judge pointed that out in her decision saying, hey, I asked him to admit or deny, they wouldn't do either. So I issued this order saying that they waived their authorization defenses, claimant shall be able to go treat on his own, and that was on May 11th. On May 17th, the defendants wrote a letter to the Dr. Dolphin's office and said, hey, don't worry about that. We're still investigating this. Don't do the surgery. So they blatantly and intentionally interfered with the client's care. Once you don't have an alt med hearing, the summary proceeding, that's it. There's nothing to appeal because it gets dismissed. There's no hearing. Then you can argue alt med at the arbitration hearing, which we did, which is part of the complaint in this case and part of what was briefed. So it is still part of the picture, just to be clear on that subject.
Ultimately, in order to recover that, you have to show that what the agency found you didn't show, which is the compensability of the injury, right?
Agreed.
Okay.
I think the logic the agency relied upon was fundamentally legally flawed because they point out what Dr. Dolphin didn't have, and I can't stress enough. Dr. Dolphin, at the time he was rendering treatment, was their authorized physician. They control care. And there's several things here, laws of line. Number one, defendants have an affirmative duty to adjust the case, and that results in them having a good obligation or a good faith obligation as a matter of law to do so. They have the duty to provide necessary info and documents.
Let's say that they had all the information to Dr. Dolphin, even though it hadn't trickled in yet, according to your opposing counsel, if they would still have the right to go to an IME, right? IME doctor?
Yes, they have a...
And they did that, right? You've acknowledged that. And that was the doctor that the agency relied on, right?
Right.
So I guess I'm at a loss then why, I mean, you might disagree with why they discounted Dr. Dolphin's opinion, but at the end of the day, it comes down to the agency gets to decide which witness they find more credible and which evidence persuades them, right?
I would encourage you to read the Asbill case in my brief. The agency didn't follow their own precedent. They didn't hold the defendants to their duty to adjust the case, to their duty to provide the CT results that they cry foul about Dr. Dolphin not having. They didn't provide them to their own doctor, and then they get the benefit of that. They didn't consult with their own authorized doctor on causation. Then they get the benefit of that. The cases make it clear that they cannot do that. The Asbill case makes it clear. The Leach case makes it clear. There's string site after string site. Employers must provide the treatment, testing, imaging, or other treatment modalities recommended by its own authorized treating physician even if another consulting physician disagrees with those recommendations. That's the law. There's no law any different than that. That's why I'm here, because what I think the problem is, these are all agency decisions. But what if the defendants just thumb their nose at the law and do it anyway? They went and got an IME and they disregarded their own treating doctor. They didn't ask about causation. They didn't provide him with records. And now they reap the benefits of it. And I'm asking this court to
They could have the IME done and pitch the IME opinion, right?
They could pitch the IME opinion to their treating doctor, which is what they should have done. There's cases briefed. They didn't do any of that. They just substituted the IME doctor for the treating doctor and said, we don't like what you have to say. I hate to be trite, but that's what happened here. And the case law says you can't do that, but it's agency case law. Then the question becomes, well, now what do we do about it? That they did everything the law says you can't do. They did it anyway. Now what? And I think that's where the court has an ability to step in here under 17A, 1910C, J, I think H. I cite them in the brief. I mean, I just don't think they can do what they did. They got away with it. They ignored a court order. The law says they can't do it. And I think it's an appropriate issue for appeal because it's a legal interpretation.
Thank you, counsel, both sides, for your efforts in your briefing, your arguments here today. I found them very informative and helpful, so thank you. We will consider this matter submitted and have a ruling out as soon as we are able. And that concludes our arguments for this session and also concludes our arguments for this week. So we stand adjourned. Thank you.